It worked out for Judge McGee, so we're glad it worked out for all of you as well, and we hope we can get this taken care of. We don't like to reset dockets because we know it's important to you and your clients to get these cases heard, and so we wanted to get it heard as soon as possible. I'm going to introduce your panel today: Judge Armstrong from Memphis, Judge McGee from Savannah, I'm Judge Golden from Memphis. And we have 3 cases here today. Y'all are all experienced litigators. I don't need to give you a whole lot of instruction, but I will remind you, we do have our timer up here. Each side has 15 minutes, and the appellant can reserve up to 5 minutes for rebuttal. And just let us know how much of that 5 minutes, if any, you would like to reserve. We don't encourage you to do it, but you have the right to do it. So we want to just mention that to you again. Is there anything we need to address?
No, Your Honor.
All right, you may call the first case.
Stacy Nicole Martin Waddell versus David Sewall Waddell.
Good afternoon.
Good afternoon.
Rachel Putnam for the appellant, Stacy Waddell. I would like to reserve 5 minutes for rebuttal.
All right, 5 minutes.
This case arises from a divorce action commenced by Ms. Waddell in August of 2017. Shortly after the original filing, Ms. Waddell filed an amended complaint and added numerous entities, 2 of which were business entities and 3 trusts. The first year of this matter was spent before Judge Rudolph, arguing over whether those entities and those trusts should be kept as parties to this divorce action. Judge Rudolph's May 23, 2018 order properly held that at that point in the proceedings, and based on the analysis that the court was to perform on a motion to dismiss, testing only the legal sufficiency of the pleading, not the evidence of the case, that the parties, having alleged that they held marital assets, were proper to be included in the divorce action. Following that ruling, Judge Rudolph was not reelected, and the case was put before Judge Corbin Johnson. Our first alleged error and the second alleged error have to do with the trial court's reversal of Judge Rudolph's order denying the motion to dismiss. We submit that Judge Corbin Johnson erred in, first of all, granting the motion to revise, as she did not provide any legal basis to do so other than a fear that there may have been an error committed. She didn't find that an error had been committed. Under the analysis of Rule 59, there was no new evidence, there was not a change in law, and there was no injustice alleged, but rather Judge Corbin Johnson found that it would be prudent to review an order that she had inherited, and that there was a possibility that there had been an error committed by Judge Rudolph. We contend that that is an error and an abuse of discretion in that there was no proper legal basis found by Judge Corbin Johnson. Following that is the motion to dismiss that Judge Corbin Johnson ended up granting, and she did so, however, prior to considering the pending second motion for leave to amend the complaint for divorce. As set forth in our brief, we believe it is a requirement for a court prior to entertaining a motion to dismiss to consider a motion for leave to amend. She did not do so, and it's stated in her order that she would consider that later. That was filed on October 30th of 2018. That motion was not considered or ruled upon until May of 2019 on the eve of the trial of this matter. So we contend an error occurred when she failed to consider that second motion for leave to amend, but then also in the substance of granting the motion to dismiss, She did not find that there had been a cause of action that had been pled that would allow her to grant relief because the cause of action of a divorce she did not find was sufficient, even though it had been alleged that the husband had placed marital assets into these various trusts, which he had complete control and dominion over, and the entities that we alleged contained marital assets, which he...
Let me ask you, Ms. Putnam, does the complaint, rather the amended complaint, actually allege that there were marital assets placed into the trust, or does it allege that the trust itself is a marital asset, which is really two different things?
Your Honor, the second amended complaint, which wife sought to file, set forth in detail the actions of husband of placing trusts, assets in those trusts, and thereby the whole trust also being a marital asset. So I would say that I think both were alleged, but the details of the transactions and why wife was asserting that those trusts contained marital assets was set forth in detail in that second amended complaint that was never ruled upon.
Also, in reading the transcript of the first day of the trial, I see that you agreed that it was not necessary for the entities to be parties to the lawsuit in order for your client to get full relief, if in fact you could show that there were marital assets placed into the trust. Do you recall saying that on the first day of trial?
Vaguely, Your Honor, yes, sir.
So why is that important now, your argument that it was error for the court to dismiss the entities since they didn't really need to be parties to get the relief that you were seeking?
Well, Your Honor, I believe at the point originally, it was unknown what the entities, whether the entities of Waddell and Associates, Inc., whether it was still operating. There were statements made that the trust still held 100% of the stocks, but that the corporation had been renamed, but it was still operating. And I believe it wasn't until 2018 that those entities were actually officially closed. And so originally, all of the entities were named and all of the trust, because obviously discovery had not been completed. But to your point, I think when at the time of trial, it was discovered throughout the preceding or following months after the denial, or granting rather, of the motion to dismiss, what held what assets. And because the two trusts, DSW and the Waddell Trust, only held stock options, and that company that the stock options came from was officially closed at that time, that is why on the first day of trial, what was said by me. At the end of the day, the entities and the trust are all, we contend, alter egos of husband. He had control of all of it. But the Focus Financial transaction that occurred on April 1st of 2016, and his decision to place the money into those trusts, made him the grantor, the trustee, and the beneficiary. And an important fact to remember is that what Focus Financial purchased was not the stock options. It was the client list of Mr. Waddell. It was the furniture, the fixtures, the goodwill of Mr. Waddell. Nothing that was purchased that he derived a benefit in excess of $13 million from was owned by any trust or the entities themselves. Those were all, because Mr. Waddell never had an employment contract with Waddell and Associates, Inc. He never had a non-compete agreement with Waddell and Associates, Inc. So what was sold belonged to Mr. Waddell, and he placed those assets in the DSW Trust and the Waddell Trust, making him the grantor, the trustee, and the beneficiary. He later then placed it in a new trust of DSW2, which he was also the grantor, trustee, and beneficiary of. There is case law which Judge Rudolph cited to in his original order denying the motion to dismiss that established in Tennessee that that type of self-settled trust would not be, could not be used as a shield for claims from a spouse for their marital and equitable share of the assets.
But I believe the case that he cited involved a case where the party was the settlor and created the trust. In this case, that's not what we had. The trusts were actually created by Mr. Waddell's father. He created the trust, made Mr. Waddell the trustee, and a trustee does not become the owner by being a trustee, nor does a trustee become the owner by being a beneficiary of the trust.
I agree with Your Honor. However, at the time of the Focus Financial transaction on April 1st, 2016, Alfred Waddell, Mr. Waddell's father, was deceased. And the only person that could make the determination as to where to place the proceeds from the purchase was Mr. Waddell. And so at that point in time, Your Honor, he became the grantor. And that is why on his 2016 tax return, it is reported all of the income and why he received the grantor letters that are required as part of that filing, because he was in fact the grantor. He was the person that exercised dominion and control and made the decision to place those monies and those stocks into those two trusts that were originally created by his father. Then he decanted those into a trust that he himself established, DSW2. And again, Your Honor, he decided to place the bulk of the marital estate, marital assets, into those trusts. Ms. Waddell, and the trial court, to her credit, did find that Ms. Waddell was an integral part of the building of the Waddell and Associates business, whether it be that she worked there for 15 years as the global communications director, albeit unpaid, but she still did, or that she was a partner in every aspect of the development of that company.
I see your time is up. One other question. Did you make an offer of proof in this case about the evidence that was excluded by the trial court's ruling?
I requested that, Your Honor, and the trial court indicated, well, we'll get to that later. This trial ended a little after midnight on July 4th. So needless to say, it was not going to happen, as it sometimes does, immediately following the trial, and she was not going to allow me to do it during the course of the trial.
So in looking through the record, we'll see that the trial court denied you the right to make an offer of proof about the excluded evidence?
I think her words were that they would deal with that later.
Okay, all right.
All right, thank you. You'll have your rebuttal.
Thank you.
I will hear from the appellee.
Afternoon, Your Honors. My name is Warren Campbell from Memphis, Tennessee, and myself with co-counsel Coble Caperton represent David Waddell, and also arguing on behalf of the other entities, we have Blaine Smith, who will be addressing more of the trust-related issues in this case.
Well, how do you plan to divide your time here?
Your Honors, we had planned for myself to take 5 minutes and for Mr. Smith to have 10, since those issues tend to be a little more intensive, but certainly can modify that to Your Honors'
No,
preference.
5 and 10 is fine. Is that what you want to do, Mr. Campbell? So you'll
Yes,
have
Your
5.
Yes, Your Honor.
And, I'm sorry, what is the other gentleman's name?
Mr. Blaine Smith, Your Honor.
Mr. Smith? All right, Mr. Smith will have 10. You may proceed.
May it please the Court. Your Honors, there are really 2 major issues that deal with trust law, and then the remaining issues are very heavily intensive on domestic law. And so I intended to speak with you mostly about those issues. The first one pertains to the continuance that was requested and denied by the trial court. In that instance, Your Honor, there had been, this case had been pending for close to 2 years, about 20 months. And frankly, there had been deadlines that weren't met in the scheduling orders. There had been other continuances granted to Ms. Waddell on other occasions. And frankly, the disclosures of the witnesses that were fact witnesses in this case occurred 48 hours before the trial was to begin on a Saturday. And so the court did not grant a continuance and also did not allow for those expert witnesses to testify, as well as the fact witnesses, due to the fact that they were late disclosed, and they were knowingly withheld as well. We know this because in Ms. Waddell's deposition in January of that year, she stated that she had the expert report and that she had seen that. The next issue, Your Honor, that I would address is whether or not the trial court refused to consider all evidence when awarding the marital assets and to make an equitable distribution. We would argue that just as we would argue in the trust issues, the trust was not a part of the marital estate. It was a separate entity in and of itself. It was settled by the grantor, Mr. Waddell's father. Mr. Waddell never owned those trusts. He never had an interest, and the businesses that were held in trust were always 100% owned by those trusts. So the court couldn't consider those as marital assets when dividing the marital estate. Also, we have a very direct case law which states that a discretionary interest in a trust does not leave, only leaves the trustee control over those assets in the trust. And also in TCA 3515-814, it's very specific in the statute that discretionary interests are neither property interests, which can be divided in a divorce, or an enforceable right. So this couldn't be considered separate property. It could not be considered marital property. It was not his property at all. With regard to alimony, Your Honor, we believe that the court did not commit an abuse of discretion with regard to that award. The court gave ample reasoning and rationale behind the award of alimony. The court also factored in Ms. Waddell's behavior, which, Your Honors, at first glance can tell that there was a lot of tumultuous litigation in this case. At the end of the day, Ms. Waddell was awarded essentially close to $1 million in alimony. She also was given 68% of the marital estate, and that was including a marital residence. So the court's award certainly is equitable. The next issue that is raised in Ms. Waddell's brief is whether or not she should have been designated the primary parent. And trial courts, as Your Honors know, have very wide discretion as far as who's designated as the primary parent and what the parenting time looks like. The court considered the factors one by one and went through that rationale. It was very specific in its ruling. 6 of those factors favored Mr. Waddell. 5 of those favored the parties fairly equally. 3 were inapplicable, and then 1 favored neither party. So based on the court's rationale, you can see it directly in the order, the court considered Mr. Waddell to be the appropriate primary parent.
What about, the court certainly went through the factors and made some determination about who the factors favored. But I looked at the transcript of the children's testimony, and as I go through that, I really don't understand how the judge weighed the factors. Like with regard to the first factor, who performed the majority of the parenting responsibility. I think it's clear from all of the proof that that should have favored the mother, yet the trial court says it favors the father.
Yes, Your Honor.
How do you answer that? How could the trial court have reached that conclusion?
Yes, Your Honor. Well, I think that issue can be really illuminated by some of the reasoning the trial court goes through in its decision and in its rulings. The court had to balance those factors against the behavior of Ms. Waddell. At various points in time, the court found that she had even...
What behavior are we talking about? Are we talking about behavior that goes to her parenting ability, or are we talking about her behavior in regard to her litigation concerning the entities? Because those are 2 different things.
Certainly, absolutely, and it does go to her ability to parent. There were points in time when Ms. Waddell would not answer the phone, and she wouldn't have a phone number that was workable for Mr. Waddell.
Was that after her phone was taken?
I apologize?
Was that before or after her phone was taken?
That was long after her phone was taken, and the number had changed on multiple occasions, Your Honor. One of the other things that the court did notice is that there was a manipulation that occurred towards the children, especially when it came to finances. Ms. Waddell specifically made the children, and the court delineates this in its ruling, she's had to balance, the trial judge, what the child testified to in trial with what she had been getting from her mother, manipulation-wise. She had led her to believe, this young girl, that she did not have enough assets to live and provide the necessities for her. And that was a huge factor in the court's decision with regard to that. The next issue is regarding...
Your time's running.
Yes, Your Honor.
Thank you.
Thank you so much.
May it please the Court, Blaine Smith of Bass, Sims, and I represent Cumberland Trust and Investment Company in its capacity as trustee of the DSW Trust Number 2, which is one of the 5 entity defendants and one of the 3 trusts that wife has attempted to make a party to this divorce case. Your Honor, DSW Trust Number 2 is a typical spendthrift, multi-generational trust at my practice that I see every day as a trust and estates lawyer that husband's father, Mr. Duke Waddell, created for the benefit of his children, husband, in this case, Mr. Waddell, and husband's children. Mrs. Waddell is not and has never been a beneficiary of this trust. And despite wife's claims otherwise, Mr. Waddell has never made any contributions to these trusts. All of those contributions originated from Mr. Duke Waddell, husband's father. These trusts all contain a spendthrift provision, which limit the ability of creditors, including spouses and ex-spouses, to reach these assets. Your Honor, as I'm sure this Court is aware, Tennessee has a long history of respecting trust and a grantor's ability to protect assets for the benefit of his family and to limit a creditor's reach. Tennessee, interestingly enough, is one of the leading states for trust and asset protection nationally, and allowing an ex-spouse to invade a third-party spendthrift trust of this type would clearly be contrary to the Tennessee Uniform Trust Code and certainly the common law. There are 4 issues that wife raises on appeal as they relate to the trust, and I'll try to touch on all of them, at least briefly. And the first issue, which wife's counsel mentioned, was the motion to revise. The motion to dismiss was initially denied, and then it was revisited by Judge Corbin Johnson, which is absolutely appropriate. Mrs. Waddell suggests that Rule 59 applies to a motion to revise, but that's not the appropriate rule. The appropriate rule, when looking at an interlocutory order, which this clearly was, is Rule 5402. And it's clear under Rule 5402 that a court can revisit any interlocutory order at any time prior to entry of final judgment. We cite 2 cases in our brief, the Schwartz case and the Compark South case. Those are on all 4s with our situation here, Your Honor, and they make it clear that the judge was appropriate in using her discretion to revisit this matter. Now, with respect to the motion to dismiss the first amended complaint, and that's really the operative pleading here, when Mrs. Putnam was up here a moment ago, she jumped to the second amended complaint and started highlighting things that were in that complaint. But that complaint is not before the court, at least not the substance of that complaint at all, Your Honor. That was not raised in their brief. They didn't. That complaint was denied on the second motion to amend as futile, and that substantive ruling was not raised in their briefing at all. There's nothing in their briefing that outlines those allegations in her brief, and of course, as we all know, that has now been waived. And so what we're really left with is the first amended complaint. And as this court may recall, the allegations in that first amended complaint were extremely bare bones. All they say is each trust holds assets and monies that are marital in nature and in which assets wife seeks an equitable interest and division, and wife and husband have made substantial contributions to the value of the trust during the marriage. That's it. There's nothing else. There's no allegations of any wrongdoing by husband. There's no allegations of any wrongdoing by the trust. There's no suggestion in there that husband made any transfers to the trust, whether fraudulent or otherwise. She just declares that they're marital property. And under the standard of Rule 12, Your Honors, that level of bare bones pleading is simply not sufficient. Wife skipped over the facts, largely because there were none, and simply jumped straight to the ultimate legal conclusion she sought from the trial court, whether the trust holds marital property. That's not sufficient, Your Honor, with no additional allegations to bring a third party into a divorce case. And of course, divorce cases are intended for the husband and the wife themselves. And when you bring in a third party, much more is needed. In addition, Your Honors, to not appropriately pleading her claims against the trust, simply as a substantive law matter, wife's claims in the first amended complaint also fail to state a claim and do not meet the substantive threshold required by Rule 12. In Tennessee, the assets of a trust of which the beneficiaries have no present possessory interest are neither marital nor separate property, and thus are not subject to division upon a divorce. And that's the Tower case. There's a long line of cases, the Eldridge case and the Wheeler case, but that's clear black letter law. Husband's interest in these trusts was merely a discretionary interest under the Tennessee Uniform Trust Code. And the Trust Code clearly provides that a discretionary interest is not a property interest nor an enforceable right. It is a mere expectancy. The husband's interest in these trusts certainly was not sufficient to rise to a present possessory interest, and wife has no claim to them. In addition, Your Honor, as I mentioned before, all of these trusts contain a spendthrift provision. And again, the spendthrift provision both limits the husband's ability to assign any interest that he might have in the trust, and it also limits any creditor's ability, certainly Mrs. Waddell's ability in this case, to reach into the assets of the trust. And Mrs. Waddell doesn't really even try to rebut these arguments. Nothing said in the opening argument has anything to do with the actual terms of these trusts. What they've done, Your Honor, is they've set up essentially a false premise. They've said, well, Mr. Waddell, he's really the settlor of these trusts, not his father, and so therefore these cases don't apply. But that is absolutely, again, not the case. First of all, there's nothing that was pled in the first amended complaint to suggest Mr. Waddell was a settlor of these cases. So just on that alone, that argument should be dismissed. But just it's clear under the estate planning documents themselves, and frankly, many of wife's own pleadings, that these trusts were set up by, again, Duke Waddell and funded by Duke Waddell. The fact that these trusts were taxed in a specific way under the Internal Revenue Code has absolutely no relevance whatsoever to who, quote, created these trusts. These trusts were funded by Mr. Duke Waddell with assets of the company. There was this focused transaction that occurred. The trust sold their interest in the company, and they received the proceeds from it. It's really as simple as that. We've made a very simple situation a complicated one. In addition, Your Honor, again, there are no allegations in the first amended complaint at all that husband transferred anything to these trusts, much less a fraudulent claim that he did something fraudulently. And of course, as we all know, claims for fraud or fraudulent transfers have to be pled with particularity. For these reasons, Your Honor, the trial court's grant of the motion to dismiss was clearly correct. Now, in her third issue on appeal, which I touched on a moment ago, wife claims that the trial court improperly dismissed her second motion to amend by not reviewing it before she dismissed the first amended complaint. But that, Your Honor, it's important to remember that the first amended complaint was dismissed without prejudice. And that's really important because in all the cases that wife cites, the dismissal was done with prejudice. And so once it was done with prejudice, the pending motion to amend could never be heard. It just went away. But that's not what happened in our case, Your Honor. Because the first amended complaint was dismissed with prejudice, the second motion to amend then went forward. We had many arguments. It was fully briefed. I was there. And the court then ruled eventually that the second motion to amend should be denied because it was futile, that wife was still unable to state a claim under Rule 12. And again, as I said earlier, That specific ruling, the futility ruling, is not before this court today. That was not raised as an issue on appeal in wife's brief. The only thing she raised was this sequence argument. That's it, as it relates to the second motion. And then briefly, Your Honor, before I use up the rest of my time, there was a third pleading that was then filed, which we are calling a third motion to amend, but wife styled as a revised and supplemental motion for leave to amend and petition to set aside fraudulent conveyance and to join third parties. Now, this was filed, almost 2 years after the initial complaint. It was filed just a few weeks before trial. The court reviewed that complaint, reviewed that attempt to amend the complaint, and applying the Rule 15 factors, determined that it was filed too late, and for reasons of undue delay, repeated failure to cure, and undue prejudice, that this third motion to amend should be denied. Thank you.
Thank you. You have 5 minutes on rebuttal.
Thank you, Your Honor. To address some of the statements made.
Let me ask you one thing that he brought up, and that is, are we in fact limited to the allegations in the first amended complaint? Do you agree with that?
I don't agree with that, Your Honor. As far as...
Did you argue the second amended complaint in your brief?
We did, Your Honor. We raised it as an issue that the court improperly denied wife's motion for leave to amend the complaint, which had the second amended complaint attached to it in that pleading.
But the motion to dismiss was based on the allegations in the first amended complaint.
The second motion to amend and the ruling thereon, I believe, should have been based upon that second motion as well as the attached proposed second amended complaint. That was all before the trial court when she entered that ruling. So the trial court had before it what wife was proposing to file as her second amended complaint and all of the detailed allegations therein, which is even more puzzling as to why she continued to state that there was no cause of action and there was not sufficient facts pled for her to be able to find that they should have been added as parties. First of all, it is an impossibility for the DSW number 2 trust to have been established by Alfred Waddell, as stated by counsel for husband. Mr. Alfred Waddell died in 2015, February of 2015. DSW 2 trust was not established until April 13th of 2016. So for him to state that Alfred Waddell established all of these trusts is simply not correct.
Well, is he not alluding to the fact that the assets of the Waddell and Associates or the company was owned by the trust? So what was sold was actually a trust asset, and then the funds of the sale were then deposited into the trust? Not Mr. Waddell's, not your client's, not Mr. David Waddell's funds, but the trust funds.
Well, I think it's been conceded. I don't think it's a contested factual issue that what was purchased by Focus Financial was not the stock that was held by those 2 trusts. Mr. Waddell's own expert, Mr. Vance, testified and acknowledged and conceded the fact that the stock of Waddell and Associates, Inc., which was the only asset held in those 2 trusts that were established by Alfred Waddell, they were not purchased by Focus Financial. And that's really the heart of the issue, Your Honor, is that what was sold in that transaction were assets that were owned by Mr. Waddell, his client list, his goodwill, his future income. All of those assets were what was the consideration for the transaction. The stock were never sold. And in fact, the stock remained in those 2 trusts. When he decanted them into DSW number 2, what was decanted was the money and the Focus Financial stock options that were worth in excess of $4 million. The stock options of Waddell and Associates, Inc. remained in the 2 trusts, the original DSW trust and the Waddell trust. And this goes to the point of what was lacking in this case was an evidentiary hearing. Judge Corbin Johnson never heard evidence about this transaction, the details of the transaction, what was sold, what was purchased. But when you examine what it was marked as ID only, the Focus Financial Purchase and Sale Agreement, it sets forth very specifically what assets were being purchased and what were being excluded. Nowhere in that document does it state that the Waddell and Associates, Inc. stock held by those two trusts was being purchased, because they weren't. And that is why Ms. Waddell continued to assert that the assets that were purchased were marital in nature. And it was Mr. Waddell's sole decision to place the proceeds of that transaction into the two trusts that were established by his father. But at that point, his father was deceased. And so he was, in fact, the grantor of those trusts.
Is that document that you just alluded to, the purchase agreement, is that part of the record?
It is, Your Honor. It is, Your Honor. And in fact, even though it's marked as ID only, both the appellees and appellant have referred to it extensively in our briefs. Additionally, in light of the lack of the evidentiary hearing, that is what precluded the trial court from actually considering these issues. And the witnesses that were excluded, she testified at length at her deposition and otherwise, Your Honor.
Thank you.
Thank you.
Ms. Putnam, again, going back to this issue of no offer of proof, if the error cited is the exclusion of evidence, how do we, as an appellate court, determine whether it was error to exclude that evidence if there's no offer of proof? What do we have to review?
You have Ms. Waddell's lengthy deposition. I think her deposition, Your Honor, went on for 4 days. And in those days of depositions, Ms. Waddell talked about many of these individuals that had knowledge of the workings of this transaction and of her contribution. The accountant that was the accountant both for Mr. and Ms. Waddell and also for the businesses was discussed. He was also excluded. Her experts were disclosed in answers to interrogatories, and a detailed explanation of what their current opinion on the situation was also provided in those interrogatories. Her experts were ordered to destroy their files, and therefore the report, which was based on those documents that they were ordered not to have, could not be produced. But they were excluded from testifying as well, and they were disclosed early on in discovery. So the court has all of that to review, the answers to interrogatories, the depositions.
And the record will bear out that these witnesses and the experts were disclosed earlier as provided for by the scheduling order?
Some of them, Your Honor. The experts were most definitely disclosed in the answers to interrogatories that were completed, I believe, originally in the late months of 2018, but then supplemented in January of 2019. And her deposition certainly goes into length of the other witnesses. It's in the record that Ms. Waddell went to her attorney's office, executed an oath page for supplemental interrogatories, which contained approximately 4 pages of witnesses. It was discovered right before the trial, that those had actually never been tendered to opposing counsel. And we've cited in our brief that when it's found by a trial court that the failure to disclose this information was more on the part of the attorney rather than the litigant, that the court should exercise discretion in granting a continuance so that that information can be explored. Thank you, Your Honors.
Thank you.